This mock trial for today will be brought to you by our team at K&S Partners. Let us quickly introduce the team. The plaintiff will be represented by its authorized representative and inventor, played by Mr. Shatadal Ghosh, and his counsel will be played by Mr. Saksham Garg. The defendant or the alleged infringer will be played by Ms. Ritu Sri Rajesh, and her counsel will be played by Mr. Satyam Rathod. The Honorable Judge at both District and High Court will be played by Mr. Saurav Vishisht, and Adhar Nautiyal will be your narrator for the session and also play the short role of Court Commissioner during the trial proceedings. Now we hand over to Mr. Adhar.
Good morning, everyone. The intention behind today's mock trial is to achieve a couple of goals. Firstly, to give you a broad demonstration and experience of what exactly transpires in a patent infringement suit in this country. Although it is true that the actual procedure before the courts may take months to years to reach its finality, the idea today is to capture some key proceedings and issues that are critical in a patent infringement suit in this country. Secondly, what we will also look at are the strategies and the decision making that is involved from the patentee's end prior to instituting a suit for infringement. This is a very important factor, as the patentee must be very mindful of the fact that the validity of the patent can be countered and challenged at any stage of the suit. So this trial will also aim to put forth the patentee's preparedness for the same. I will now briefly summarize the subject matter of today's mock trial. The patentee's product is a leak-proof plastic molded one-piece compact ball valve which has a certain shape to it, and the material that it is made up of is plastic. On the other hand, the alleged infringer or the defendant here has a similar looking product but with a slightly different look and feel. Today's trial will essentially look at the fact that whether the defendant's product is covered by the independent claims of the patent and is thus infringing the suit patent. I would also like to mention that the patentee in today's trial or the plaintiff is a large-sized multinational company based in Bengaluru, and the defendant is also a small to mid-sized company not based in Bengaluru. Without much ado, let us now begin the proceedings today by hearing out the inventor of this patent on something that has caused him much concern.
Good morning. I'm Dr. Ghosh. I'm Group Technical Head Manufacturing of Aviation Pipes. Aviation Pipes is a world-leading company producing a wide range of industrial products. Let me tell you a little bit more about us. We are a European company formed in 1954. We sell a wide variety of products in more than 100 countries. One of our best-selling products is a compact leak-proof ball valve. We sell about 10 million of these worldwide every year, and out of those, 3 million are sold in India itself. Our product is protected in India by our patent IN 123456, which was granted in November 2012. We launched our product in India in 2013, and we have had very good sales. Unfortunately, in 2022, we observed a significant drop in sales. We investigated the reason for the drop, and we found out that a copycat product was being sold in the market by some entity we had never heard before of, Red Peak Pipes Private Limited. The loss to us was so severe that if we did not take immediate action, we would lose a huge chunk of our market share. This is when we engaged our counsel, who has collected some information regarding this.
Good morning, Dr. Ghosh. As per your instructions, we've made some inquiries and we've procured the infringing products. As instructed, we've sent them to a government accredited laboratory for testing in order to degree the degree of infringement.
Yes, I'm aware of that.
See, upon analyzing the test report and based on our own analysis, we've determined that the product being sold by Red Peak Pipes falls well within the scope of your patent.
That is good news. That is clear-cut infringement then.
Further, we have approached and sought expert opinion of a reputed professor, Dr. S. Ray of Bharati Engineering College, who is the head of Department of Mechanical Engineering. Professor Ray is also of the same opinion that this product clearly falls within the scope of the granted patent IN 123456.
That is really good news. In fact, Professor Ray was my PhD advisor. Now, I have one question. apart from his opinion, since I am also a technical person and I am listed as one of the inventors in the patent, should I also submit an affidavit regarding the similarity of that infringing product and our product?
See, while you are a technical person, and not only are you a technical person, you are the mentioned and stated inventor of the patent. However, since you are an employee of the plaintiff, it is advisable to proceed with an independent third party just to remove any prejudice from the mind of the judge. And being the inventor and in-house expert as well, you might be considered biased.
Okay, understood.
Now, we have all the major information required to file a suit for patent infringement. Since you're suffering from a loss of sales, our first goal is to get a court order prohibiting red beak pipes from manufacturing the infringing product.
Before we file the suit, should we send a cease and desist to Red Beak?
Let me tell you, there are certain repercussions involved in sending a cease and desist notice to an infringing company. Once we serve a notice to them, they would know that we are onto them and they can anticipate legal action. They can approach the court before us and ask for some reliefs. These reliefs can include a suit for declaration, or they can also ask the court that in the suit any order should not be passed without them being given a prior hearing. It is preferable to send a notice only if the infringer is considered reasonable or a reputable company, or if we have good reason to believe that we can get the infringer to stop manufacturing the infringing product simply by sending legal notice and threatening them with legal consequences.
Okay, that makes sense. So then let's go ahead as per your advice and let me know whatever further information you need from us. We'll give it to you.
See, we would require your Indian sales figures from January 2022, since that is when we anticipate that Red Beak pipes will start in manufacturing, and for the prior years in order to determine the damages to be sought. These need to be certified by SCA. We would also need your Form 27 statements.
What is this Form 27 statement?
See, Form 27 statements are working statements required to be filed under Section 146 of the Patents Act to show that you, the patentee, are in fact working your patent on a commercial level in the country. The patentee is given the monopoly in lieu of, it's a quid pro quo for making available its invention in the market so that the public can benefit from the same. In the meanwhile, please do keep in mind that we have to maintain complete confidentiality. Please ask your employees and all associates that no information is leaked. That will compromise our case by allowing Red Beak to anticipate legal action.
Okay, I understand. Now, my next question is, where would we be filing the suit?
See, we would be filing the suit in Bangalore only, since we have procured the infringing product here. Any place where the product is available for sale or delivery automatically confers jurisdiction on the local district court and high court in some cases.
But as far as we know, Red Beak is located outside of Bangalore. So don't we have to file a suit where Red Beak is located?
Yes, but since you and I both are based out of Bangalore, one, it is a convenient forum for us. Secondly, we also have a commercial court in Bangalore, which will ensure a speedy trial under the Commercial Courts Act as well. So I will suggest Bangalore as the place to file the suit.
Okay, Bangalore it is there.
Great. We'll prepare a draft suit and we'll share it with you for review before going ahead and filing the suit.
Okay, great. I will be waiting for your draft. Thank you very much.
Amen.
We'll now proceed to the courtroom where the plaintiff's counsel will make submissions before the Honorable District Court seeking ex parte ad interim injunction.
My lords, this is a suit for patent infringement of suit patent 123456. Certified copy filed as document number 1. Next, my lords, may I request you to please turn to document number 2, which is a patent certificate procured from the Indian Patent Office. This certificate substantiates that the suit patent was granted to the plaintiff, it's valid and subsisting as on date in the Indian jurisdiction with a remaining expiry period for 10 years. My lordship may next turn to document 3, which shows that the plaintiff, Aviation Pipes, is a multinational company of good repute. The images of plaintiff's product manufactured in accordance with the suit patent are at document number 5, my lords. Next, my lords, kindly turn to document number 5, which is the independent CA certificate substantiating the loss of sale for this particular product. If we refer to the figures, it clearly suggests that somewhere in early 2022, there was a dip in the sales. which further died down staggeringly in the second and third consequent quarters of 2022. We have also projected a loss of sale of this product and the consequent loss of revenue that will be caused to the plaintiff company in the next 3 to 4 quarters. My Lordships, we did our own investigation and came across the defendant company Red Private Limited. Their company details can be gathered from the incorporation certificate filed as document number 6. Next, my lords, the infringing product have already been procured and delivered within the jurisdiction of this honorable court. The infringing product itself has been filed as document number 12. On the right hand side, you will see that is the patent image of the suit patent showing a cross section of the plaintiff's invention, and on the left is the infringing product. Further, please see document 7, which is a printout of A to Z website, which clearly shows that the defendant is offering the product for sale and delivery within this district. The plaintiff's team has procured these products by online means. If my lordship may next turn to document number 8, we have produced an invoice from A to Z.com which showcases that the product has been purchased via online means and delivered within the jurisdiction of this court, thereby establishing that this court has the requisite territorial jurisdiction to try the suit. Next, my lords, we have also sent the infringing products to a government accredited laboratory for testing, so that we know various parameters like the materials used in the product, the dimensions and the functionality and so forth. At document number 9, we have produced such reports which clearly show that the infringing product of Red Peak Pipes implements all features of the independent claims of suit patent IN 456. Next, my lords, in addition, we've also sent these products to an independent expert for his evaluation, and we've received his opinion. The independent expert, Professor S. Ray, is a reputed professor in the mechanical engineering department of one of the leading institutes of the country. The Professor Ray is also of the same opinion that this product clearly falls within the scope of the granted patent. We've provided such external affidavit at document number 10. We've also filed working statements of the suit patent by the plaintiff as document number 11. Lordship, with all due respect, we have thoroughly established a case of prima facie infringement by virtue of test reports, infringement analysis, and independent expert opinion. Further, if the defendant is allowed to continue to manufacture and sell its product, irreparable harm will be caused to the plaintiff by loss of sales and consequent loss of revenue. This is directly attributable to the defendant's infringing product in the market. Thus, in my humble submission, the balance of convenience also lies in favor of the plaintiff. Specifically, since one, it is a bona fide patent holder, has been working its patent in the Indian market, is the industry leader, and has approached this court without any delay. Whereas the defendant is a manufacturer in the market for at least the last 1 year who is producing the infringing product without any license from the plaintiff, a product which is a clear imitation of the plaintiff's patent. Additionally, in the present case, urgent ex parte relief is also required because the plaintiff is unaware of the extent and nature of defendant's infringing activity, and it is anticipated that if the defendant is made aware of legal action, they may destroy or dispose of the infringing goods. Thus, it is humbly submitted that this is a fit case for grant of ex parte ad interim injunction in our favor. That's all, my lords.
The plaintiff has filed IA number 1 of 2023 under Order 39, Rule 1 and 2 and Section 151 of CPC. Praying for an order of ad interim injunction restraining the defendants, their directors, employees, officers, servants, agents, associates, group companies and all other acting on their behalf for using, making, selling, distributing, advertising, exporting, importing and offering for sale, or in any other manner, directly or indirectly, dealing in any product that is covered by the infringed subject matter patent 123456, which is titled as a leak-proof plastic molded one-piece compact wall, including but not limited to the brand name Splash Wall or any other claim. I have heard arguments of advocate plaintiff, and per use the record, I am of the opinion that the plaintiff has made out a prima facie case for grant of ad interim injunction. I am also of the opinion that irreparable harm or injury would be caused to the plaintiff at this stage if the defendant is not restrained from dealing in the impunged product immediately. I am further of the opinion that prima facie the balance of convenience lies in the favor of plaintiff. Also, the plaintiff has reduced enough evidence to show that the defendant is a fly-by-night operator. If alerted of the plaintiff's action approaching this court, would dispose of the otherwise destroy the modify the stocks of such infringing goods. Hence, this court is of the opinion that if a grant of ad interim injunction is delayed by giving notice to defendant, it may defeat the purpose of the injunction itself. Accordingly, this court issues an ex parte ad interim injunction against the defendant as prayed therein till next date of hearing, which hearing shall not be later than 2 weeks. Defendant to be issued suit summon, including a copy of this order returnable within 1 week. Further, defendant may file its reply to plaintiff's interim order injunction application and is granted liberty to seek an earlier hearing. Provision of Order 39, Rule 3 of CPC be complied with by the plaintiff at or within 2 days of the order.
Obliged, my lords.
We'll now hear from the defendant in the suit who has received the summons of the suit. She has approached her counsel for advice and strategy.
Good morning, Mr. Satyam Rathod. I am Ritu Rajesh and the Director of Operations at Reddy Pipes Private Limited. We are in the business of manufacturing pipes and other plumbing works for the last 10 years. I am shocked because we've been served with some order from the Bangalore District Court, this is the order, against manufacturing our products /valve. Please help us.
Okay, so Ms. Ritu, this appears to be a patent infringement suit in relation to a patent IN 123456 over some ball valve. Let me first ask you a few questions. How long have you been manufacturing this particular product?
We recently started manufacturing /valve in the month of January 2022.
Okay, and were you aware of the plaintiff's patent when you started manufacturing this product?
No, not at all.
Okay, so can you tell me, are there other similar ball valves in the market?
Yes, many.
So how is your product different from the patent?
There are multiple points of difference.
Okay, please share a brief write-up of the difference.
Sir,
Okay, so Ms. Ritu, we can protect your company in 2 ways now. Firstly, we can argue that your product is very different from the plaintiff's patent and hence is not infringing. The other way is to show to the court that the plaintiff's patent itself is wrongly granted and is invalid. To show invalidity of the plaintiff's patent, we will need to look for relevant prior art documents, which will show that the plaintiff's patent was anticipated by previous inventions. In other words, the patent's patent is not novel and is obvious. We will conduct this research for you and we will share a list of document and information that we will need from you for preparing the reply. And once we have what we need, we will draft a counterclaim as well as reply to the plaintiff's interim injunction application. Please note that once the counterclaim has been filed, the suit will stand transferred from the District Court to the High Court of Karnataka.
certainly. Thank you, Mr. Satya.
Thank you so much.
The defendant has filed its counterclaim, written statement and applications before the district court. Under section 104 of the Patents Act, the suit is transferred to the Honorable High Court for adjudication. We will now hear arguments from counsels for both parties before the Honorable High Court on interim injunction, starting with the defendant.
My lord, I represent the defendant in the present matter. My lord, in nutshell, the present patent infringement suit is nothing but a malified attempt of the plaintiff to thwart competition in the market. My lord, we have filed our objections to the interim injunction application as well as we have also filed a counterclaim challenging the validity of the suit patent under section 64 of the Patents Act. My lord, the suit patent is invalid on multiple statutory grounds, including that it lacks novelty and it lacks inventive step. My lord, ball valves are not new in the industry and they have been known in the industry since many years. I have filed my prior acts which substantiate the same along with the counterclaim, my lord. Further, my lord, the defendant suffers grave economic hardship due to the ex parte ad interim order which has been passed and which is in force. My lord, it is vital to note that the said order was passed ex parte by the district court and we were not given an opportunity to present our case. There are several material facts, my lord, including lack of jurisdiction, that have been concealed from this court, and thus the injunction granted should be vacated, my lord. My lord, also the plaintiff has filed one expert affidavit to substantiate its infringement claim, my lord. The independence and credibility of the so-called expert Mr. Ray, whose analysis is the primary basis of infringement claim of the plaintiff, my lord, is also disputed. He has been appointed by the plaintiff and hence the biasness cannot be ruled out. My lord, injunction has been obtained based upon misrepresenting our product to be infringing the suit patent. Please see the product of both the parties, my lord. My lord, thus on a prima facie view, our products are substantially different from that of the plaintiff's product. My lord, I repeat, on account of ex parte order, the defendant, which is a very small company, has faced significant loss and hardship in terms of business, my lord. Therefore, balance of convenience lies in favor of the defendant. My lord, defendant will suffer immensely if the ex parte order isn't lifted. Therefore, my lord, I most humbly pray that the ex parte ad interim order be vacated, or at least it be modified in the interest of justice, my lord. That's all from my side.
My lords, in my humble submission, defendant has not been able to raise any challenge to the validity of the patent at this stage. The arguments are feeble at best. The patent has stood the test of time for the past 10 years since it was granted and has stood unopposed, unchallenged in any revocation proceedings. The plaintiff will nevertheless file its written statement to the detailed counterclaim, and any challenge to the validity of the patent may be determined at trial. Second, my lords, the defendant's contentions regarding ex parte injunction. I submit that there are a plethora of cases in patent infringement with similar facts, where high courts have passed ex parte orders where such relief was urgently and immediately required, owing to the nature of the infringing activities of the defendant. Specifically, in the present case, since the defendant is a fly-by-night operator, such relief was urgently required and rightly granted by the Honorable District Court. In any case, the plaintiff has met the threshold for the grant of interim injunction, since it has shown a prima facie case, balance of convenience, and immediate and irreparable damage to my client. Thirdly, my lords, there is no concealment of facts from this Honorable Court. The plaintiff has clearly mentioned that the jurisdiction vests with this court of this district by virtue of online sale of the product and delivery within the jurisdiction of this Honorable Court. It is well established by judgments of various courts that a commercial transaction using online means, targeting the forum state by the defendant, resulting in injury or harm to the plaintiff, will give rise to the jurisdiction of the court of that state to try the suit. Fourthly, on the issue of non-infringement, my learned friend here has been misleading this court by comparing the infringing product with the plaintiff's product. That is not the threshold of proof. The law is very clear on the fact that the infringing product has to be compared with the granted claims of the suit patent, a burden the plaintiff has clearly discharged. Also, there is no bias. Professor Ray is independent and stalwart professor from the reputed engineering college. His analysis agrees and reinforces the results of the lab report. Thus, at present, there is no credible challenge to infringement as well. Finally, the defendant has not only not countered my infringement analysis, but has not submitted any non-infringement report of its own. Thus, in my humble submission, this is a case where the ex parte ad interim injunction granted by the learned district court is continued as interim injunction till final disposal of the suit, and it is prayed that the matter proceed to trial.
Counsels, I am proposing that the defendants can continue manufacturing the alleged infringing product on the condition they can submit a bank guarantee to an approximate amount calculating the damages, so calculated, and they can submit a monthly statement of their accounts of sales of the alleged infringing products. So, counsels, do you agree to that?
That's fine with us, my lord.
My lords, we have no objections either.
So I've heard Mr. Saksham Garg, counsel of plaintiff, and Mr. Satyam Rathod, the counsel for the defendant in the present matter. The present application IA number 1 and 2 of 2023 have been listed pursuant to defendant's application for transfer from the 8th additional district and session judge Bengaluru under section 104 of the Patent Act. praying for transfer of the suit in view of counterclaim filed by the defendants challenging the validity of the patent. The defendant, without prejudice to its rights and contentions, state that it wishes to continue manufacturing and selling goods which our plaintiff alleges be infringing its patent. And they are ready and willing to abide by any condition which this court may be pleased to order. The plaintiff's counsel fairly states that its interests are secured. Plaintiff would not have any objection to defendant selling the infringing goods within India. So it is proposed to the defendants and is agreed that the defendant can deposit in a court a bank guarantee of an amount approximate damages calculated at a rate computed according to para 46 and 47 of the claim, and the same is to be renewed annually. Defendants further undertake to file a periodic statement of accounts of sales of the alleged infringing product with the court during the pendency of the present suit. I am further of the view that at this stage, ad interim injunction for deposit. At this stage, ad interim stage, no direction for deposit or payment of arrears claimed out not be passed. However, as long as the claims of the plaintiff to past damages and for any future profit are secured, the defendant out not be restrained. In the light of the matter and believing accepting the aforesaid statements, assurances and representations made on behalf of defendants and binding defendant thereto, the subject to the defendant undertaking to this court, furnished to the plaintiff and also file this court at the end of each month by the 5th day of succeeding month the particulars of manufacture, sale and import of devices using the subject technology, and to deposit to this bank court guarantee an amount approximate damages claimed by the plaintiff at a rate computed according to the para 46 and 47 of the claim, and same is to be renewed annually. The defendant may be allowed to sell only within the territory of India its alleged infringing product. The above undertaking offered are accepted, and defendants, including the directors, is ordered to be bound therewith. The counsel for the plaintiff and the counsel for the defendant state that the pleadings in this suit have been completed. The counterclaim filed by the defendant to be numbered, and the counsel for the plaintiff accepts the summons notice of the counterclaim. Written statement to the counterclaim to be filed within 4 weeks, and replication in any within further 2 weeks thereof. The parties are to file affidavits of evidence and marking of exhibits for the affidavit of admission. Denial of each document be completed within further 2 weeks. The parties are ordered to submit their respective issues and proposed trial schedule to this court, a detailed court order on issues and case management schedule to follow. Mr. Adhar Nautiyal is hereby appointed as court commissioner who will preside over the trial. His fees shall be borne by both the parties. Registrar is directed to take necessary steps in this regard.
We'll now proceed to trial. We will be beginning with the cross-examination of the plaintiff by the defendant's counsel.
Mr. Ghosh, can you identify your signature in this affidavit?
Firstly, it's Dr. Ghosh.
Okay.
And yes, I have signed above the term deponent and on every page as well.
So, Dr. Ghosh, who drafted this affidavit for you?
I did in consultation with my legal counsel.
So, you are saying that your legal counsel helped you to draft it. I presume he also got it notarized for you.
No, he did not.
Dr. Ghosh, I put it to you that you were not even in India on the date of notarization of this affidavit.
I object. This is going beyond the affidavit of the plaintiff.
Witness can answer to be decided by the court.
I was in India at the time and I can submit a valid proof for the same as and when required.
So, Dr. Ghosh, what are your educational qualifications?
I have an MTech and a PhD in Mechanical Engineering from Indian College of Engineering. My thesis was entitled Multi-Phase Hydrodynamic Flow Modeling Using Finite Element Methods. It was conferred the Best PhD Dissertation Award in 2000 by the Indian Association of Chemical and Mechanical Engineers.
Okay. Dr. Ghosh, what exactly was your contribution as an inventor of patent number 1, 2, 3, 4, 5, 6?
I was an integral part of the core team in the conception and development of the invention.
Dr. Ghosh, that does not answer my question. What exactly was your contribution? You actually say in para 7 of your affidavit that you were the co-lead of the project which developed the product in question. Could you name the other lead?
As VP of R&D, I was the lead for flow modeling and Mr. Ramesh was leading from the mechanical design department.
Dr. Ghosh, you mentioned that Mr. Ramesh was the other co-lead, but that is not reflected in the application for the suit patent in any jurisdiction. Why is that so?
Yes. Mr. Ramesh did some initial work for the development of the invention, but he left our organization before the invention could be perfected and the suit patent application could be filed.
As you are only one of the co-lead and Mr. Ramesh is not an inventor of the suit patent, I put it to you that the suit patent does not cover my client's product splash wall.
I object, my lords. Legal analysis should not be allowed in during cross-examination.
Witness can answer, the court can decide.
In my opinion and experience, the defendant's splash valve is very well covered within the suit patent.
Are you aware of the Patents Act 1970?
Yes, I believe you're asking me about the Indian Patents Act. I'm generally aware of the provisions in that act.
Are you qualified to practice patent law?
No, I'm not a qualified lawyer.
And were you involved in any patent litigation before this?
No.
Okay. I put it to you, Dr. Ghosh, that you have no knowledge of patent law and you cannot interpret a patent document.
By virtue of my experience and my educational qualifications, I'm generally aware of patent law. I have around 10 patents to my credit.
So I can safely presume that you are not aware of the concepts of novelty and obviousness?
I object, my lords. The question is presumptive.
The witness can answer, the court can decide.
As I stated earlier, I have knowledge of patents from my experience and I understand the basic tenets of patent law.
Kindly look at the suit patent and let me know if the leak-proof compact ball valves claimed in this patent was novel as on the date of priority of this patent, namely 16/11/2010.
In my opinion, the invention was novel as on the date of priority of this patent, and accordingly, patents have been granted in many jurisdictions all over the world, including in India.
In that case, Dr. Ghosh, kindly point out the novel and inventive features of the suit patent, please.
I would like to refer to paragraph 13 of my affidavit, where I've pointed out the novel features of the suit patent. So firstly, the disclosed invention stands apart from conventional leak-proof ball valves, where the ball valve disclosed in the patent is a single-piece molded unit, which does not require any assembly. A conventional ball valve requires assembly by the user before it can be used in the machinery. Secondly, the ball valves in the prior art only had a single ball in them, while our invention has two in the valves. Thirdly, the closing and the opening of the ball in the suit patent is externally controlled using a handle, as opposed to the prior art where there is no such handle for closing and opening of the ball. Fourthly, our invention exhibits equally spaced apart grooves as compared to the opposite spaced apart locking arms for fitting with the pipes. This allows for a stronger seal. These grooves also allow for fixing O-rings to these grooves, which further improves the leak prevention aspect of our invention as compared to the ball valves in the prior. These features are an improvement on the ball valves previously available in the market. They make our invention far superior than the previously available products in preventing the leak and the spill of harmful fluids. I have been advised by my legal counsel that these features disclosed in the patent are novel and inventive. Since there were no other product with these features were also non-obvious and have industrial applicability.
So, Dr. Ghosh, I put it to you that the present invention is disclosed under the prior art document D1 and D1 destroys the novelty of the suit patent. What do you have to say about this?
I deny this suggestion. The invention disclosed in the patent envisages a single piece mold unit, whereas the invention in D1 has a complete separation of the valve and the housing. So to use the invention in D1, you require assembly, which is not required for our patent. Therefore, our invention is a different product than what is disclosed in D1. Also, D1 does not disclose the other novel features which I just mentioned to you before.
Dr. Ghosh, I put it to you that ball valves are well known in the pipeline industry for controlling the flow of fluid and that your invention has no technical advance over other ball valves in the market. The prior art document D2 also clearly shows that the ball valves are commonplace.
You're quite mistaken. While the use of a single ball in the valve is well known, the technical advance in our invention, in our patent, is that we use two of them. The provision of using two of them ensures that the flow of fluids only happens when the bore in both of these balls aligns with the fluid passageway in the pipeline. This allows us to control the flow of fluid with greater sensitivity and also prevents the leakage of harmful fluids, harmful gases or harmful liquids. The prior art also does not show any handle which is present in our invention. The handle in our invention allows for the opening and closing of the valve and allows us to finely tune the flow of fluids through the valve for any given pressure. So that for any pressure, we can control the amount of fluid which is flowing through per unit time.
Dr. Ghosh, the prior art D1 and D2 in combination discloses ball valves with grooves. I put it to you that any difference in your product are merely superficial and have no bearing on the functionality.
You are quite wrong. Firstly, no prior art shows the combination of a ball valve with grooves. The prior art shows that these features existed separately. Our invention exhibits a technical advance of combining both of these to make a new product. Furthermore, the grooves are equally spaced apart, which allows the use of O-rings for even better sealing and prevention of leaks. When two pipes are held together by these grooves and by adding O-rings, we can make a much better fit and a much better seal. This is also a technical advance of the prior art which did not disclose the use of O-rings.
So, Dr. Ghosh, I put it to you that the suit patent of the plaintiff is invalid and you have merely combined prior arts to come up with a ball valve and are attempting to get away with a patent for the same. What do you have to say on this?
That is completely incorrect. In view of my detailed answers which I have given above, my patent is valid and subsisting. There is no combination of prior arts. The suit patent has been granted in multiple countries including in India after rigorous examination.
Dr. Ghosh, there's a product kept on your table on the left. Is this your product?
Yes.
And on the right, is that the defendant's product?
Yes.
These look very different. Do you agree?
Only superficially, if you just look at the aesthetics. The defendant's product imitates the essential elements of our patent and thus it infringes our patent.
Please look at the defendant's product closely, Dr. Ghosh. Can you see that the elevated periphery which breaks in the middle and again elevates and this pattern is repeated?
Yes, but if you...
These elevations, Dr. Ghosh, breaks in my client's product are not the same as in your product. I put it to you that this is clear evidence of non-infringement on my client's part and that my client's product does not infringe your patent at all.
That's wrong. Infringement does not depend on the similarity between my product and the infringer's product. It depends on whether the infringer's product incorporates elements that have been claimed in my patent and not my product. As I've explained above, clearly, our patent claimed equally spaced apart grooves that can accommodate O-rings to provide a better seal. What you are claiming as elevations and breaks in elevation are functionally identical to the grooves claimed in our patent and differ merely superficially in some design aspect which is more aesthetic rather than functional. As we've also shown, the defendant's product can also accommodate O-rings. It is obvious that the defendant's product infringes our patent.
Dr. Ghosh, I put it to you that there is no infringement of your invalid suit patent and the plaintiff is only attempting to thwart the defendant's business by filing this malicious suit for infringement and illegally suppressing competition in the market.
I object. This is irrelevant and witness cannot answer on intent.
Witness can answer. Let the court decide.
This is completely false. I state again, the suit patent is valid. Infringement of the suit patent is clear from the infringement analysis filed by me. The infringing product clearly copies the elements of our invention in the patent. It incorporates the grooves where the O-rings can be fitted. It incorporates a handle to control the flow. It has two balls as described in our patent, and it copies a single molded unit concept. We're not attempting to thwart the defendant's business, we're only trying to protect our rights. We have produced a new product which is very useful and we want to be lawfully compensated for putting our efforts in for researching and developing and making this product. In fact, Professor Ray's expert opinion also clearly shows the infringement.
Dr. Ghosh, I put it to you that the expert affidavit of Professor Ray, relied upon by you in your affidavit, has been prepared under the instructions of the plaintiff. What do you have to say on this?
Yes.
I put it to you that the plaintiff provided their in-house results to Professor Ray to prepare his affidavit.
Yes, we did.
And I put it to you that Professor Ray is not aware of the content of his affidavit and has not drafted the same in his individual capacity. What do you have to say on this?
I object to this. This question is very suggestive and cannot be answered by the plaintiff.
No, he can answer. Let the court decide.
I deny the suggestion. We had no role and we did not influence him in any way in his final conclusions.
And how did you select Professor Ray to provide an expert affidavit?
Professor Ray is an internationally renowned expert in fluid mechanics. He has many books and publications in peer-reviewed journals in his name. He is also the head of Department of Mechanical Engineering at Bharati Engineering College. His stellar CV is the reason why he was approached to provide an expert opinion.
And Professor Ray was your PhD advisor at Indian College of Engineering?
Yes, he was.
And you had a close working relationship with Professor Ray during your PhD?
Obviously, you cannot do a dissertation otherwise.
And you have continued to have a close working relationship with Dr. Ray?
I object, my lord. The question is very much irrelevant to this present case.
My lord, it is very much relevant and will be evident as we proceed.
The witness can answer, the court can decide.
Presently, I would call it close. At least it's not as close as it was while I was doing my PhD. But of course, we come across each other in conferences and seminars because we work in the same field. I follow his academic publication with great interest. I learn a lot from them.
And have you engaged Professor Ray to provide his expert opinion in other disputes?
I object. This is not relevant to the present case.
So the witness can answer, this court can decide.
Yes, we have.
And exactly how many times?
To the best of my knowledge, in 5 other matters.
How much did you pay Professor Ray to prepare his expert affidavit in this particular matter?
My lords, I object. This is confidential information and this is not relevant to the present case.
The witness can answer, let the court decide.
We gave him a small honorarium of around rupees 1 lakh.
And Dr. Ghosh, how much in total have you paid Professor Ray for his expert affidavits in all the matters he has participated in as your expert?
My lords, my same objection to this line of questioning may be recorded.
Let him answer, the court can decide.
I mean, I don't have the exact figure. To the best of my knowledge, it should be around 5 lakh rupees.
Dr. Ghosh, I put it to you that Professor Ray has been engaged by you so many times, it is only because he can be relied upon to give an expert affidavit in your favor.
My lords, this is not only irrelevant to the case, but this is also defamatory to a reputed professor of the country.
Let him answer, the court can decide on this.
That is an outrageous suggestion. He's a world-renowned expert and he has been engaged by other parties in infringement suits all the time, both patentees as well as defendants. He's also one of the youngest winners of the Shanti Swarup Bhatnagar Prize. If he was known to be biased, we and others would definitely not engage him as an expert as he would have no credibility.
Okay, Dr. Ghosh, I put it to you that your testimony, including your affidavit, is biased, argumentative, and false.
I completely and absolutely deny that suggestion.
Thank you for your cooperation, Dr. Ghosh. That's all from my side, my lord.
So we'll now begin the cross-examination of the defendant by the plaintiff's counsel.
Good morning, Ms. Ritu. For starters, can you identify your signatures in the affidavit?
Yes, these are my signatures.
So it is you who drafted this affidavit, correct?
This affidavit is drafted in consultation with my counsel and facts known to me.
What are your educational qualifications?
I have a bachelor's in engineering, to be specific mechanical, and a diploma in machine design.
And what is your current designation in the defendant company?
I'm the director of operations.
When did you start working with the defendant company and what was your designation at the time?
Since the last 10 years as an assistant manager in product development department.
So can you please explain your roles and responsibilities starting from the date of your first employment till the present date?
So it is to conceptualize, innovate and develop products. We collaborate with various teams on technology, design and marketing for core product development, and also define success metrics and reporting needs to monitor post-launch performance. As a director of operations, I'm an overall in charge of our manufacturing operations.
These are very generalistic terms that you're stating your role in. Can you be a little more specific about that?
You can always refer to my CV that is produced with my affidavit. I'm the director of operations and I have a lot of duties.
Alright. I must say that it's a long journey from assistant manager to becoming the director of your operations. What do you have to say about that?
I object, my lord. The question is going beyond the scope of affidavit and is presumptive in nature.
I agree. Counsel, please reframe your question.
Okay. Then let me ask you this. If you are the director of operations, then you must be aware that the infringing product is available for delivery within Bangalore.
I do not know. I can't be personally expected to be aware of all the locations of delivery of our product.
Okay, but at least can you tell what is the market share of your company specifically related to the sales of the infringing product?
I cannot recall the exact market share off the top of my head, but this splash valve is one of the most successful products of our company.
And since when has your company been engaged in manufacturing of the said splash valve?
As I've already explained, we've been in the pipes and fittings market from the very beginning. This particular product was launched in January 2022.
Alright. Please refer to the annual return submitted by you along with your written statement and clarify whether figures indicated in the annual turnover of your company are cumulative figures of your entire range of products.
Yes, they are.
Can you please bifurcate your annual turnover and give me a figure for the contribution made by the infringing product in question?
See, this is difficult to segregate that in the annual turnover. However, I have produced an independent CA certificate having details of the sales made by splash valve. So I would like you to refer to the same.
What is the approximate manufacturing cost of one piece of your product?
I object, my lord. This is confidential information and this is beyond the witness affidavit.
She can answer. Let the court decide on this.
It's around 40-45 rupees.
And how much does one piece of your product sell for in the market?
100 rupees.
I would like you to refer to your annual report. As per the same, the annual turnover of your company for the year 2022-23 is INR 10 crore. Am I correct?
Yes.
I would now like you to refer to the independent CA certificate submitted by you. As per said CA certificate, your company sold 750,000 units. Am I correct?
These are broad numbers. I will have to refer to my books and consult my CA for the exact figures.
So at least presently I can presume that the product in question contributed around 7.5 crores to the annual turnover of your company. Is that correct?
Objected, my lord. The question is presumptive in nature.
There is no harm in the question being allowed. The admissibility can be decided by the Honorable Court, but the witness can answer on this.
As I told earlier, manufacturing cost of my product is in the range of 40-45 rupees. Hence, it's difficult to arrive at the numbers suggested by you.
Mr. Rajesh, I am simply asking whether is it safe to presume that the product in question contributed 7.5 crores in the annual turnover of your company. I am not asking for the exact figures but an approximation based on your own CA certificate.
See, in my opinion, the figures arrived by you might not be accurate. We have other products too, but this product has indeed been a success.
So are you suggesting that the annual turnover of your company is majorly attributed to the product in question?
My lord, I object. This is repetitive and presumptive in nature.
Let her answer. It can be decided by the Honorable Court. Witness can proceed.
Well, that may not be an accurate presumption. I've never made any such submission.
Alright, we'll proceed. Ms. Ritu, do you consider yourself an expert in the field of mechanical engineering?
Yes, I've completed my graduation in mechanical engineering.
But I put it to you that that does not make you technically qualified to opine on infringement and validity, and you are not qualified to depose this affidavit.
That is completely incorrect. I am technically competent to give my long-standing experience in the field and with this company.
Alright, if that is so, can you please explain what you understand by the term prior art?
Yes, I understand the term to refer to as earlier technology.
And what do you understand by the terms novelty and inventive step?
Those terms I understand generally.
I put it to you that you do not have a clear understanding of the above terms, specifically in respect of the Patents Act 1970. What do you have to say about that?
I do understand the term generally, but if you're asking me for a legal definition, I'm not a lawyer.
Since when did you start manufacturing your product, the splash valve?
January 2022.
And how did you come up with the product?
So working in product development, it's part of my job. We identified a gap in the market at the time and arrived at this product.
Can you please state what gap exactly did you identify in the market?
We identified that the leak proofing in the earlier valves was not up to the mark and we could improve on that.
All right. Kindly refer to the plaintiff's infringement analysis report. What do you have to say about that?
I do not agree, as my product is completely different from your product, although both products are similar for application purposes, but they're not identical.
Please see the report again. How do you describe the following features? That is, two balls for the ball valves, manual handle for functioning of the valves, grooves on the outer surface of the for receiving O-rings. These have been clearly shown and mapped to your product, the splash valve. What do you have to say?
Once again, I'm not in agreement with the report. I was unaware of your patent and consequently I was not even aware about the ball and the grooves which you are alleging as similar.
Alright, then I put it to you that the characterizing portion of the suit patent is actually present in your ball valve. What do you have to say about that?
No, it is not. The characterizing portion is not present in our valve. The grooves are not present in my product. The infringement analysis report is incorrect and your indication in the product's valve is also incorrect.
Alright, then how does your product prevent leakage?
So our product prevents leakage or spillage because of the elevated periphery which breaks in the middle and again elevates continuously. The material used on such elevated periphery enhances the protection from leaks is different.
Does your product have O-rings present in the elevated periphery?
No, our products does not have O-rings, but there is a different material that is put on the elevated periphery.
Please explain in detail what is the product or material that is used on the periphery of your device.
I am aware that the plaintiff's valves use grooves with O-rings to enhance protection from leaks by providing a better fit on pipes, but the material used by us is slightly thicker but not the same. I am not aware of the exact differences that are there in the material.
Ms. Ritu, I put it to you that the shape of the material used by you on the outer periphery of the valve is identical to the plaintiff's valve. It serves the same exact purpose too.
The shape has to be circular, yes. They say they serve the similar purpose, but both are not identical. The design is different in splash valve. As a valve manufacturer, it is obvious that the purpose for it is to prevent leakage or spillage, which is also the purpose of the plaintiff's valve. So it's evident that both products serve the same purpose.
I put it to you that the grooves in the suit patent are the same as the elevated periphery in your product. The material used by you on said elevated periphery is same as the O-ring of the plaintiff's product and patent, and they both serve the same purpose. And also the external handle for functioning of the valve is also present in your product. What do you have to say?
That is completely incorrect. The design is different in our product. The material is slightly thicker. Periphery is more elevated. The handle is just a standard improvement. It is obvious that the two products serve the same purpose.
I put it to you that your product has all the features of the suit patent. There are no major differences in the two, but only design and aesthetic changes. And your product has been developed by infringing and illegally copying the invention of the suit patent. What do you have to say?
That is completely incorrect and denied. The two products look dissimilar.
Alright, let's move on to the counterclaim filed by you. You have stated earlier that you were involved in the drafting of the counterclaim and have knowledge of patents. Can you confirm if you've read the prior art documents filed by you, D1 and D2, as well as the suit patent in detail?
Yes, I have.
Alright, how are the multiple ball valves feature present in the document D1?
No, the exact feature is not present in documents D1 and D2. I suggest that you look closely. While the number of such balls are different in both ball valves, but the functioning is not affected by this difference.
I put it to you that single ball valves were not as successful in serving the purpose of preventing leakage. What do you have to say?
I cannot comment on the efficiency, but there's always some leakage or spillage.
Is the feature of O-rings of suit patent which prevent all leakage and spillage present in documents D1 and D2?
I don't know whether the exact feature is present in document D1 or D2.
Alright, then can you kindly go through documents D1 and D2 and point out where in each document has the characterizing feature of the invention been disclosed?
said feature in document 1 and 2 at the moment.
Alright. Can you please refer to the documents again and state what are the problem statements stated in both documents?
D1 aims to make a leak-proof valve, but I cannot say that the problem being solved by suit patent and D1 is exactly the same, but mostly similar. Again, D2 is trying to make a leak-proof valve, but the problem statement might not be identical.
Alright. So do D1, D2 and the plaintiff's patent share the same object and problem being solved?
No, they solve different problems.
Alright. Kindly again refer to the documents D1 and D2 and please state where is the motivation for a skilled person to combine the teachings of D1 and D2 and arrive at the problem solved by the present suit patent.
Like I said, since both documents belong to similar field of invention, a skilled person may read D1 and then D2 and then easily combine their teachings to invent similar leak-proof valves. However, I cannot state where the exact motivation to combine these documents lie.
I put it to you that you have not gone through documents D1 and D2 and specifically you don't know what is the objective problems of said prior arts.
That is incorrect. I have gone through the documents.
Ms. Ritu, I put it to you that you have not even searched any prior arts and these prior arts were provided to you by your own attorneys.
That is false. Our entire team and I have collectively searched the prior art documents produced before this court.
Alright. Then how do you consider whether a prior art is relevant for the purpose of your affidavit or not?
The disclosures in the prior art are similar to those in the patent.
Ms. Ritu, I put it to you that you arrived at documents D1 and D2 by conducting a mere Google search and have not conducted any prior art search.
We conducted a prior art search to check whether my product is non-infringing. I don't remember the results I had got back then. I can only say that I've come up with this product on my own.
Why is there no challenge to the validity of the suit patents then in either pre-grant or post-grant proceedings?
See, I was not aware that the patent existed. If I would have known, I would have definitely filed and opposed.
Ms. Ritu, I put it to you that you've never seen any valve which comprises more than one ball for the valves or grooves on the outer periphery for receiving O-rings in such valves of prior art, and that you've never seen them both used together in one single product prior to the suit patent. What do you have to say about that?
Single ball valves and grooves have been known separately for almost 30 years prior to the plaintiff's patents.
I put it to you that you've never seen any valve with grooves on the outer periphery specifically for receiving O-rings as present in the plaintiff's patent. What is your response?
I can't comment since I did not know of the plaintiff's patent.
I put it to you that you've never seen any valve with exterior handle also present on it prior to the plaintiff's patent.
This is a standard feature, but I cannot specifically remember where I've seen this, but it's quite common in the industry.
Ms. Ritu, I put it to you that you've never seen any valve with all the features mentioned in the suit patent in combination prior to the plaintiff's product, which was showcased specifically in the plumbing industry's magazine, which was prior to the launch of your product. What do you have to say?
I'm not aware of any such magazine, but I can say there must be more players in the market developing a similar valve.
Ms. Ritu, I put it to you finally that the counterclaim filed by you is false.
No, the counterclaim is not false. It is drafted to the best of my knowledge.
Finally, I put it to you that your testimony, including your affidavit, is biased, argumentative, and completely false.
I deny this suggestion.
Thank you, Ms. Ritu, for your cooperation.
We'll now proceed to hear final arguments from counsels for both the parties, starting with the plaintiff.
My lords, this is a clear and straightforward case of blatant infringement of plaintiff's patent by the defendant, and the same has now been established firmly by extensive trial. Firstly, the present dispute involves three key issues for my lordship's consideration. First, whether this court has the requisite jurisdiction to entertain the present suit. Second, whether the plaintiff's patent is valid and novel and inventive. Third, whether the defendant's valve is infringing the suit patent. Regarding the first issue, whether this court has the jurisdiction to entertain the suit, my lords, in my humble submission, the invoices submitted to this court clearly show that the defendant have a commercial nexus within the jurisdiction of this honorable court. Even though the registration of the company is in another jurisdiction, it has not been denied by the defendant during cross-examination that the product is available throughout the territory of India. Further, upon being specifically examined, the defendant clearly stated that it is not aware that the product is available for delivery within this jurisdiction of this court. However, no clear denial was received from the defendant, but only that they cannot be personally expected to be aware of all locations of delivery of its product. This in itself clearly shows that this court has the requisite jurisdiction to try this suit. Secondly, with regard to the issue pertaining to the validity of patents, the evidence of both parties has clearly established that before the plaintiff invented the patented ball valve in the year 2012, the ball valves or prior art valves were provided with only a single one ball having opposed spaced apart locking arms instead of grooves, which consequently provided only minimal safety from leaks. This has been admitted by the defendant itself during the cross-examination at page 6 in response to question number 13. The defendant has also admitted that such earlier ball valves suffer from the obvious disadvantage of leaks. Now, my lords, this very problem was identified by the plaintiff, and in order to solve the same, the plaintiff, after extensive research, came up with a patented ball valve more than 10 years ago, which was registered as Indian patent number 123456 2 years later. This invention facilitated providing higher safety from leaks. The plaintiff also started using its valves on pipes in the year 2013 in line with its own patent, which is evidenced by the plaintiff's working statements. Next, my lords, the plaintiff has clearly evidenced that its valves are novel and inventive. You can refer to the testimony of the plaintiff witness in questions 16 to 19 for this. In these questions, the plaintiff has been able to establish that multiple balls for ball valves, external handle, its grooves for receiving O-rings, which is intrinsic to the functionality of the valve, that is to provide enhanced safety from leaks. This was not countered by the defendant in response to questions 20 to 22. Thus, my lords, the novelty itself stands proved. In respect of inventive step, the inventive step of the patent lies in the feature that two pipes can be held on to each other by virtue of outer grooves and O-rings, which make the two pipes to be held together tightly and provide enhanced protection from leaks. The defendant has questioned the plaintiff on the above extensively, and the above technical advancement achieved by the means of the suit patent has been clearly brought out in the plaintiff's cross. Thus, the defendant's argument that the plaintiff is merely a combination of two known valves, one with a single ball in the valve and the second grooves on the outer periphery, is inherently flawed. The plaintiff's valve is clearly novel and inventive of the prior art cited by the defendant, and the arguments raised by the defendant are merely in hindsight. Additionally, it was also established that closing and opening of the ball valves as suggested in the suit patent is externally controlled using a handle. This is also not present in any of the prior arts. Moreover, the defendant has admitted during cross-examination that even the object of the prior arts cited in the counterclaim have a different scope and different objective than to the invention of the suit patent. The prior arts cited by the defendant are solving a completely different problem altogether and are not relevant to the instant invention. This itself goes against the settled law of inventive step in the case of Roche v. Sifla, where the arguments grounds of challenge to the plaintiff ought to be dismissed. Next, my lords, regarding infringement by defendant's product of the claims in the present patent, the evidence led by parties has clearly established the following points. The plaintiff's patent has been valid and subsisting for the last 10 years unchallenged. Secondly, the defendant's witness, despite claiming that the defendant's product is different and does not have grooves and O-ring, which is the characterized feature, has admitted at least to the following. One, that its valve prevents spillage or leakage because of the elevated periphery. A material is received in the elevated periphery which enhances protection from leaks. The defendant's periphery and material are only grooves with O-rings for enhancing protection from leaks by providing a better fit on pipes. This is essentially same to the plaintiff's valve. Thus, There is no counter to the plaintiff's technical report and expert analysis because they don't have any. In conclusion, the defendant's valve is also a double valve which is identical to the plaintiff's leak-proof ball valve with grooves configured to receive O-rings. The dissimilarities pointed out by the defendant in this product are nothing but trivial and trifling design modifications without any functional implications. This cannot absolve the defendant from his liability of infringement. The defendant has clearly admitted that its product is essentially implementing every feature of the plaintiff's patent. My lords, the defendant, by using the suit patent on their products, would unmistakably cause confusion among customers at large and thereby take advantage of the plaintiff's hard work and efforts in developing the suit patent and the products thereunder, which have earned enormous reputation and goodwill in the market. It is further submitted that illegal and malified use of the suit patent by the defendants have inevitably resulted in causing substantial loss and damage to the plaintiff's business and reputation at large. The plaintiff has further proven that the damages incurred by it in loss of profits is directly attributable to the infringing activities of the defendant. The extent or amount of damages is substantiated by the account of sales filed by the defendant in this court. Accordingly, damages should be granted from the date of first manufacture of the infringing product in favor of the plaintiff along with him. That is all from my side, Lord.
My lord, I appear for the defendant and would be addressing my arguments on each of the issues framed by this honorable court. The issues are whether this court has jurisdiction to entertain the present suit, whether the plaintiff is the proprietor of the Indian patent number 123456, whether the patent number 123456 is valid, whether the defendants have been infringing patent number 123456 of the plaintiff, and any damages which can be claimed. My lord, on the issue of the jurisdiction, I would like to point out that this suit has been instituted only to arm twist the defendant. Admittedly, the defendant is not based out of Bangalore. The present suit has been filed on the basis of a single isolated invoice, my lord, showcasing procurement of the defendant's product through certain third-party online merchant, which is not even authorized exclusive dealer of the defendant, my lord. Therefore, there exists no substantive ground, my lord, to invoke the jurisdiction of this honorable court in relation to the present suit. Thus, my humble submission is that issue 1 be decided in favor of the defendant and against the plaintiff, my lord. My lord, as far as issue number 2 is concerned, that is whether the plaintiff is the proprietor of Indian patent number 123456, my lord, it is pertinent to note that PW1 has admitted that one Mr. Ramesh was also one of the inventors in the suit patent, of the suit patent. However, the same doesn't reflect in the patent grant certificate, my lord, neither in the patent application. Therefore, it is very doubtful whether the plaintiff had the right to file the patent application for the present patent in its own name without obtaining Form 1 or assignment from Mr. Ramesh. Therefore, my lord, I humbly submit that this issue be decided against the plaintiff and in favor of the defendant. My lord, as far as issue number 3 is concerned, that is whether the patent number 123456 is valid, my lord, the suit patent ought to be revoked as the same is completely invalid. My counterclaim presents in detail the reasoning behind the said submission of mine, my lord. Moving on, my lord, it is vital to note that the features of the suit patent are not novel at all, and the same was publicly known and was publicly used in India before the priority date of the claim or to what was published in India and elsewhere also, my lord. My lord, ball walls were known in the industry much before the suit patent. I place my reliance, my lord, upon document number 1 and 2 which I have filed and which have been marked as exhibit number 1 and 2 respectively. My lord, a perusal of the said document clearly indicates that ball walls were disclosed in the said document. D1 title, my lord, wall made of plastic was published way back in the year 2008. It is evident that the ball wall described in the said suit patent was disclosed in this particular publication. Hence, my lord, the suit patent is not novel. Also, document number 2, which is titled Plastic Stop Wall Method of Production, was published way back in the year 2003. And the said document demonstrates that all the features of the suit patent was disclosed in the said document way back in 2003. Plaintiff has done nothing, my lord, but slavishly copied all the features from these documents. My lord, it is further vital to note that the suit patent lacks inventive step and is obvious. The ingredient of document number 1, my lord, is ball valve made of plastic, adjusting spindle with grooves for accommodating sealing rings, and sleeves mounted around the adjusting spindle such that the sleeve presses the sealing rings, my lord. My lord, a person skilled in the art can arrive at the alleged invention in the suit patent, and the same is being claimed as an invention by merely changing the nomenclature and using two balls instead of one. It is well known, my lord, that spindles are synonymous to ball stem, and sealing rings are synonymous to O-rings, and sleeve is synonymous with bushes. Therefore, my lord, there is nothing inventive or new, and a person skilled in the art can reproduce the suit patent independently from the teachings in document number 1. My lord, I further submit that the suit patent does not solve any existing problem. When we compare document number 2 and the suit patent, it is very obvious that the suit patent is nothing but a virtual reproduction of the invention claim in document number 2, my lord. The plaintiff has not solved any existing problem of setback using the suit patent, nor has it demonstrated any improvement which is inventive, and the solution provided neither leads to a technical advancement nor provides any economic significance. The mere usage of handle and two balls instead of one doesn't lead to any technical contribution at all, my lord. Hence, the suit patent lacks inventive step and is completely obvious to a person skilled in the art. My lord, it is further vital to note here that the suit patent doesn't even qualifies to be an invention. The entire arrangement of the suit patent is a mere rearrangement of the known components which we have seen in T1 and T2, and they are working in a known way without any interplay between the components. Hence, my lord, the suit patent is liable to be revoked on this ground alone. My lord, here I would like to refer to the Honorable Supreme Court decision in the case of Biswanath Prasad Radheshyam versus Hindustan Metal Industries, my lord. The specific para it reads, I would like to quote, my lord. To be patentable, the improvement or the combination must produce a new result, or a new article, or a better or cheaper article than before. The combination of known integers may also be combined that by their working interrelation they produce a new process or improved result. Mere collation of more than one integers or thing not invoking the exercise of any inventive faculty does not qualify for the grant of patent. My lord, the present case exactly fits in this particular guideline issued by the Supreme Court in this judgment. Therefore, my lord, the rearrangement of known devices as we see, which functions independently of each other as demonstrated, is not patentable, and the suit patent, my lord, is liable to be revoked on this ground alone. My lord, coming to the issue of infringement of suit patent, I would like to submit that the products of the defendant do not infringe upon the suit patent, as the defendant's product is totally different from the suit patent, my lord. It is, it is very much visible from the naked eye itself, my lord, when comparing both the products. Further, I submit, my lord, that the affidavit of the so-called expert Dr. S. Ray is also vehemently disputed. It is pertinent to note, my lord, that the PW1 has himself admitted during the cross that the said affidavit was drafted under the plaintiff's instructions and in accordance with the results of the plaintiff's internal infringement analysis, which was provided to Dr. S. Ray by the plaintiff. My lord, this is sufficient to establish that the evidence of Dr. S. Ray is not independent but totally biased towards the plaintiff. Moreover, my lord, the PW1 had also admitted having paid a hefty amount to Dr. S. Ray for the same. My lord, now I leave it to the wisdom of this honorable court to decide as to how such an affidavit can be taken into account to determine infringement, which smells of biasness from the beginning. My lord, the plaintiff's sole claim of infringement is based upon the so-called expert's affidavit, that is Dr. Ray's affidavit. Therefore, my lord, I submit that the plaintiff's claim of infringement should be outrightly rejected on this ground alone. My lord, even otherwise, the defendant's product is visibly distinguishable from the suit patent. My lord, if my lord could refer to claim 1 of the suit patent, it relates to a ball valve used in plumbing applications, and the essential claim elements of claim 1 include a wall body with an inlet and outlet, ball stem with 2 grooves, O-rings on grooves of the ball stem, and a plastic bush which is pressed between the ball stem and the wall body on O-ring to prevent leakage of fluid, my lord. My lord, on the other hand, the defendant's product is a ball valve used in plumbing application, and the defendant's product include the following particular elements, my lord. Firstly, a wall body with an inlet and outlet. Secondly, ball stem with grooves, my lord. And thirdly, O-rings on grooves of the ball stem. O-rings seal the gap between the ball stem and the wall body to prevent leakage of the fluid, my lord. My lord, it is very important to note here that unlike the suit patent, the product of the defendant does not require or include a plastic bush which is pressed between the ball stem and the wall body on the O-ring to prevent leakage of fluid, my lord. Such a requirement of plastic bush adds to number of components and increase the cost of the wall valve. My lord, in view of the above, product of the defendant clearly falls outside the scope of claim 1 of the suit patent and therefore doesn't infringe patent number 1, 2, 3, 4, 5, 6 of the plaintiff. As far as issue number 5, that is damages, is concerned, my lord, it has been categorically established that the suit patent is not valid and must be revoked, and the defendant's product is not at all infringing the suit patent. Therefore, my lord, the present issue should be decided against the plaintiff and in favor of the defendant. At last, my lord, I humbly submit that the present suit be decreed in favor of the defendant and against the plaintiff, with heavy cost imposed upon the plaintiff, my lord, for wasting the judicial time of this honorable court. Much obliged.
The plaintiff has filed the present suit alleging infringement by the defendant in Indian Applic Patent number 123456 and seeking the release of permanent injunction, rendition of accounts, damages and other ancillary relief. On the basis of pleadings of parties, following issues were settled: whether this court has jurisdiction to try this suit, whether the patent is a valid patent or not, whether the plaintiff is the proprietor of this patent, whether defendants have been infringing this patent, and what are the damages, if any. Plaintiff, in support of its case, examined one witness, Shadadal Ghosh, referred as PW1, and defendants also examined the witness, Ritu Shri Rajesh, as PW1. Firstly, on the issue of jurisdiction, it is clear that the product of defendants are available or ordered via e-commerce websites within the jurisdiction of this court. This fact has not been denied by the defendants. The law is clear on this issue, and the same cannot be assailed or differentiated by the defendant's counsel in the present case. Accordingly, the defendant's application is dismissed, and this court will proceed further having proper jurisdiction to try this. On issue number 2, secondly, the plaintiff has clearly evidenced that it is the proprietor of the suit patent which has been filed, prosecuted and successfully granted in its favor. The plaintiff has further shown following of its patent without any opposition or challenges or any encumbrance since its grant. Accordingly, this issue is granted in favor of plaintiff. Before delving into the issue of infringement, we first consider the issue of validity of suit patent. The defendant has filed its written statements and also challenged the validity of suit patent in the counterclaim. However, no separate invocation petitions were filed before filing the present suit. The main defense raised by the defendants in the written statement is that under the Act, the validity of patent must be first established before the issue of infringement is considered by them. The defendant has led evidence and argued at length on invalidity of the suit patent. Defendant's counsel contends that the suit patent is not valid due to the lack of novelty and is an obvious invention to the person skilled in the art, since it's already disclosed in the published documents produced before the court. The prior art produced by the defendant is argued to be enabling, and thus the defendants pray for revocation of the suit patent in the court. Briefly, the plaintiff's counsel, Mr. Saksham Garg, argued that at very least, first one, the ball valve in the suit patent uses 2 balls, whereas the such arrangement has not been suggested in any of the paragraphs. The valves, as described in the patent, have equally spaced apart grooves that are capable of receiving O-rings, which are not being showcased in any previous patent or prior document. There is present an exterior handle in the valve which allows selective closing and opening of the valve, and such selective opening and closing, specifically with the help of handle, is not showcased in any of the previous patents, and hence the patent is novel and inventive over the patent. I have heard counsels appearing for both parties at length. This court opines that a patentable invention must involve something which is new and outside the probable capacity of a craftsman, which is expressed by saying it must be new subject matter or involve an inventive step. Novelty and inventive step are obviously closely allied. Although these issues must be pleaded separately, both are raised by the defendant together. The plaintiff has clearly shown its invention to be novel over both prior arts individually. Additionally, the plaintiff has clearly distinguished the problem statement of both prior arts from the invention of the suit patent. Moreover, the plaintiff has been able to establish that there is no motivation in prior arts document D1 or D2 to combine the same. The plaintiff has further demonstrated that the characterization portion of claim 1 of the suit patent is absent in prior art document, either taken alone or in any combination. For all aforesaid reasons, this court finds that defendant has not been able to successfully prove its ground of challenging the validity of suit patent. This court has no hesitation in holding that the suit patent valve was certainly a new product with a novel improvement and also involves an inventive step, having regard to what was publicly known or used at the date of patent. The grant of patent in question was therefore valid, and there is need for this court to intervene or revoke the same. The counterclaim of defendant is thus dismissed with no cause. On the issue of infringement 2, this court finds that the plaintiff has been able to successfully evidence that the defendant's product essentially implements all essential features of the suit patent. The additional feature argued by the defendants are mere trivial aesthetic modifications. There is no invention over and above the suit patent in the defendant's product. Thus, the court finds that the issue 4 of infringement is also decided in favor of plaintiff and against the defendants. Coming to reliefs, in view of the above discussion, the suit is decreed in favor of plaintiff and against the defendants, holding that the said defendant have been infringing the suit patent numbers 1, 2, 3, 4. The plaintiff is also found entitled to a degree for recovery of loss of profits incurred directly or owing to infringing acts of the defendant. The profits payable shall be calculated at a rate determined from the profit margin, which could have been earned by sales of plaintiff's product from the date of the first manufacture of the infringing product by the defendant till the date of final payment per product sold by the defendant, along with an interest rate of 10% per annum from the end of the month. The above calculation is to be based on the certified sales figures and projections of the plaintiff's filed with the plaintiff. Certified statements of accounts submitted by the defendant, including a final statement to be filed by the defendant till the date of execution of the present. Additionally, a decree of permanent injunction is also passed in favor of plaintiff and against the defendant for future manufacture. Lest the defendant negotiate a license for future manufacture with the plaintiff or mutually agreeable terms. The parties are left to bear their own legal costs. The suit is disposed of and the degree shall be prepared accordingly.